Good afternoon, everybody. I'm Samantha from the law offices of Samantha Wolf, and I really appreciate y'all being here this afternoon. We're going to talk about the tricks of Medicaid. So we thought with it being October, we would tie in the theme of Halloween and trick or treat. So today, that's what we're going to talk about. So for those of you who haven't been to our office, we're located at 20 East 6th Street, Suite 206 in Waynesboro, and you can reach us by calling 717-655-2676. This is our mission statement. I always like to start off our presentation just reminding everybody that we really do appreciate the opportunity to serve you, and we're happy to be here and provide that support for you and your family. Okay, so Medicaid, is it a trick or is it a treat? And how do we handle Medicaid rules? How do we qualify for Medicaid? What can we do to help our families be able to pay for long-term care services? So that's what we're going to talk about today. So long-term care we deal with just because people are living longer. We're seeing great advances in the medical field. And so this means that we're seeing people live in assisted living and personal care, independent living, and then moving to skilled level care. And so we have to learn how to navigate the rules that help our family, help the individuals in our life qualify for Medicaid benefits. So what is long-term care planning? So here at our office, what we consider long-term care planning is the process of planning for your future should anyone require long-term care. And it's really about protecting those assets. We're not trying to hide anything, we're just protecting it, whether it be for the surviving spouse, might be that you're helping parent, spouse, or future generations. That's really what we try to do here at our office is engage in long-term care planning. So how do we pay for long-term care? So I wanted to just briefly mention this. We do have a November 2020 virtual seminar that we have titled Grandma Got Sent to a Nursing Home. And in there, we talk really a lot about all the specifics of the ways that you can pay for long-term care. And we go through the veterans benefits and the Medicare in detail. So today, I just wanted to have this slide in here talking about ways that you can pay for long-term care. So obviously, you can pay for it out of pocket, privately paying. You can also have long-term care insurance or other private medical insurance that can help pay for your long-term care. You can also receive Medicare. We will touch on this just briefly. You can be receiving veterans benefits, or the way that most people who aren't privately paying for long-term care, they're paying through Medicaid, and the Medicaid funds are used for that. So to the extent you want to know the specifics about the Medicare and the veterans benefits and how they work, if you go to our YouTube channel and just type in, so if you go to YouTube and type in the Law Offices of Samantha Wolf, we have a channel and we have a playlist that covers all of our virtual seminars, and the one dealing with grandma getting sent to the nursing home, that's the one that has all of those details in it. So I encourage you to go back and take a peek at that one. Okay, so what is Medicare? So if there's a delay, Jess and I are working out the timing, so sorry about that. So what is Medicare? So Medicare and Medicaid are often confused for each other. Medicare is the federal health insurance program that's used to insure individuals in the following categories. So anyone age 65 or older, anyone under age 65 if they have certain disabilities, if somebody has end-stage renal disease, or if somebody has Lou Gehrig's disease. So Medicare is really health insurance. So when I'm meeting with clients, they may say, well, mom, dad, spouse, whoever is trying to qualify for Medicare. What they really mean is Medicaid, because Medicare obviously is that federal health insurance. Now, it does work with Medicaid, and we're going to talk about that in the next couple of slides. But I wanted to at least talk about how Medicare is really the health insurance component of it, and Medicaid is really the long-term care component of it. So Medicare, how it works covering long-term care and skilled facilities is that Medicare, because it is the health insurance, it will cover up to 100 days. So day 1 through 20, the individual is not going to have any copay. Medicare covers 100% of that. Day 21 to 100, there's a copay, and in 2021, that's 185.50 is the daily amount. And then Medicare picks up the rest. And then day 100 and beyond, there's no coverage through Medicare. And that's where Medicaid kicks in, because Medicare was a program that was never designed to protect against long-term care. It was really designed to be health insurance for a short period of time. So that's why Medicare isn't going to cover past 100 days. Now, a couple of things worth noting here is that if you are receiving the benefits through Medicare, so up to the 100 days, it does require a 3-day hospitalization. So one of the things that we're dealing with right now is that we have some people who go into the hospital and they aren't actually admitted. They're just in the observation status, is what they call it. And if they're never actually admitted into the hospital, then Medicare is never actually kicking in to help cover up to 100 days. So you always have to make sure when you, your spouse, or a family member is in the hospital, you want to make sure what is their status? Are they observation status, or are they actually being admitted into the hospital? And if so, then Medicare can cover up to 100 days. The other thing to know about Medicare is that a couple years ago, there was a court case that said that they can no longer say if you've plateaued, because remember, Medicare covers up to 100 days. And sometimes what facilities would say is that the patient has plateaued, and so they're no longer going to be covered under Medicare, even if the 100 days hasn't been used. Okay. So if you're in day, let's say 60, they may say, well, no, you plateaued, and so Medicare is not going to cover anymore. What's important to know is that it's no longer a plateau status. It's the status saying that if you didn't continue receiving this treatment, you would decline. And as long as you're in that category, then Medicare will continue to cover up to 100 days. So I want to briefly mention that. The other important thing to note, which is why we're going to talk about Medicaid, is Medicare does not cover long-term care, nursing home care. It doesn't cover dental, vision, or hearing aids. So when you're talking about going to a skilled facility, just remember Medicare covers up to 100 days, but it's not going to cover anything in excess of that. So what is Medicaid? So Medicaid is a state federal program that's going to pay for your healthcare services. Pennsylvania administers this program through the Pennsylvania Department of Human Services, or DHS is what we call it. And most people needing long-term care are eventually going to qualify for Medicaid at some point, unless they're in a continuing care retirement community or a CCRC, which we do have a couple of those here in our community. And that's because the CCRC is really where you're paying a certain amount to be admitted into that facility, and then they're promising to pay through your entire continuum of care. So that's a little bit different than a traditional long-term care facility or a traditional nursing home. So it's important to know what type of facility are you wanting to go to. Now, just know that even if you're at a CCRC, it doesn't mean that they don't get individuals to qualify for Medicaid. It just means that the way that they go about doing it is a little bit different than a traditional nursing home. And 2/3 of all nursing home residents will be or are receiving Medicaid benefits. So that's important to know. It affects a lot of people. So we wanted to make sure to kind of give you a snapshot of what Pennsylvania looks like in regards to the entire United States. So what we did is Amy researched the 10 states with the highest Medicaid enrollment in 2021, and Pennsylvania is at number 5. So that's important to know because here we do have a lot of those in retirement age and beyond who are living in Pennsylvania. And if 2/3 of people are on Medicaid, and we know that Pennsylvania is number 5 in Medicaid enrollment, it's important to know how do we go about enrolling in Medicaid, or when do we need to go about enrolling in Medicaid? So the average cost of long-term care, they change this every year. So in 2021, it's $11,099 per month for a nursing home. And that's the average in Pennsylvania. That means that some counties are going to be a little bit higher, some counties are going to be a little bit lower. But what we can say is across the whole state of Pennsylvania, the average cost is $11,099 per month. That means it's about $133,000 a year. Now, assisted living is usually less than that. It's 3,000 to 4,000 is the average. The daily rate, the average daily rate to pay for long-term care is $364.90. And I wanted to add this in the presentation, and the reason is because a lot of times we'll have clients who want to talk about long-term care insurance or some sort of insurance with a long-term care rider. And it's important to know that the daily rate does increase every year, because if you do have an investment that's paying for your long-term care, sometimes there's still a shortfall. between what the insurance policy will cover. So for example, if it covers $275 a day, and we know that the average daily rate is $364, there's still going to be a shortfall where you're either going to have to privately pay or Medicaid is going to have to cover that. So that's why it's important to know what the daily average rate is, because if you do have some type of insurance product, you still may need Medicaid at some point. The other thing I wanted to mention is the whole reason for this presentation isn't really talking about, for example, how we qualify, down to the brass tacks and nails. But what I wanted to do is talk about just fundamentally, what are the Medicaid requirements? And here, the whole goal of this is to talk about if you want to protect assets and qualify for Medicaid, there are ways that you can do that. And again, it's not really at all the ways that we're going to talk about this. It isn't really about hiding assets, and it's not about the nursing home not getting the funds. It's really about protecting the spouse, and we're going to get to that, protecting the spouse and protecting your kids for the assets that you've worked hard for. So that's really what the angle that we're kind of coming at this from. So, but in order to do that, we have to know what are the resource limits that Medicaid has. So there's two ways that Medicaid will cover you. So the first is that if you're considered categorically needy, non-money payment. This is for individuals with low income and low resources. And the cutoff for this is all about what your monthly income is. So if you are a husband and wife, or if you're an individual, these numbers count the same. So for example, I'm going to use my parents as an example. Let's say my dad goes into the nursing home. My mom, as what we call the community spouse, the spouse that doesn't go into the nursing home, she has her own asset limits that she can keep. And we're going to get to that in a little bit. But I wanted to have this slide talking about what my dad's qualifications would be and what income and assets he's allowed to keep. So this would apply for a married couple to the spouse who's considered the institutionalized spouse or the spouse that's going into the nursing home. But it would also, this slide also applies if you are a single individual who's looking for Medicaid and what it covers. So it's all about your monthly income, your gross income. So right now, starting January 1st, 2021, the cutoff is $2,382 a month. So if you have income that is less than that, then you're allowed to keep $8,000 in resources. That's a $2,000 amount plus an additional $6,000 set aside resource. So they disregard that and they allow those with income less than the $2,382 more resources because their income is lower. So that individual or that institutionalized spouse, if you're in a couple, would be allowed to keep $8,000. If you are in the other category, which is medically needy only, and that covers individuals with slightly higher income where they're incurring higher medical or long-term care cost expenses. And so if you have a monthly income of over $2,382 a month, then that means that you're only allowed to keep resources in the amount of $2,400. So whenever we're meeting with clients, whether you are an individual or whether you're the institutionalized spouse of a married couple, first we're trying to establish what are you allowed to keep. So it's either going to be $8,000 of resources or it's going to be $2,400 of resources. Okay. The next thing that we do is we then look at what we call the community spouse. So in my example where my dad is the one who goes into a nursing home, the community spouse would be my mom. She's the nursing home or the spouse who doesn't need nursing home care. She'd be considered the community spouse. So when we're talking about my dad, we would first look at what can he keep. So can he keep $2,400 or can he keep $8,000? Then we pivot and we look at my mom and we say, what can my mom keep? And the way we're able to determine that is first, we kind of take an intake of all the assets that a married couple has, because there are some assets that are considered exempt, meaning that the nursing home cannot look at them during life to pay for care. And we're going to talk about why that's important, that part about during life. We're going to talk about how that changes when someone passes away. But the first thing to know is, what can the community spouse keep? So the community spouse, in this example, my mom, can keep her retirement. Her retirement isn't used to pay for my dad's care. My dad's retirement could be used to pay for his own care, but my mom's retirement can't be used to pay for my mom or my dad's care. So that's the first thing. The community spouse's retirement is not available for the institutionalized spouse. The second thing to know is that if my parents have multiple vehicles, my mom can keep the vehicle of highest value. Regardless of how it's titled, she can keep the vehicle of highest value. The third thing my mom can keep is the primary residence as long as she keeps it as her primary residence. And why is that important? So sometimes we have individuals who, or married couples, who will come in and they will say, we're going to go ahead and title it over into our kids' names. Or they may say, we're going to sell it. And as soon as you convert it, either in title to someone else, or if you sell it, then that does become available during life. So if my mom, for example, decides to sell the primary residence, it would take an asset that was exempt and immediately make it available for my dad's care. So if they haven't done any long-term care planning, if they haven't met with us here at our office, what I would tell my mom to do is she's going to keep it as the primary residence, because then as long as she's living in the house, then the nursing home can't force the sale of the primary residence to pay for dad's care. Now, the important thing to know is I may tell my mom, well, we may want to take my dad's name off the deed, because if my dad dies while in the facility, the issue is that the nursing home through DHS, Department of Human Services, can actually put a Medicaid recovery lien on the house, so that when my mom passes away, then the nursing home can recoup, Medicaid can recoup what they've paid towards my dad's care. So that's why it's important to know, although the primary residence is exempt while living, as long as it's a primary residence, it is still subject to a Medicaid recovery lien. So that's important to know. The other thing my mom can keep, as we're going through the list of things that mom can keep, she'd be allowed to keep about $130,000. Now this does go up every year. So when I first started practicing, it was somewhere around 120,000, and it has increased every year. So now we're at 130,000. And then lastly, my mom can keep income if she needs more than what she's earning every month. So let's say my mom has $1,000 worth of income that she's receiving, whether it be through Social Security or maybe through her retirement benefits, whatever that amount is. Let's say she's getting $1,000 a month, but her monthly expenses are $1,300. So there's a shortfall. What we're able to do in that case is we can divert some of my dad's income to my mom so that she can still pay for those expenses. So please know that there is an income component, making sure that the community spouse does have enough income to pay for those expenses. So just real quickly, the community spouse is allowed to keep their own retirement, one vehicle of highest value, the primary residence, about 130,000, and then any additional income needed to cover their expenses. The rest of their assets, whether it's titled in my dad's name or my mom's name, is going to be available to pay for my dad's care. So that's what we really want to talk about today, is the fact that if that would happen for my parents, and we know that the average cost of nursing home for 1 year is close to 135,000, even if my parents have saved a lot, if my dad needs care for longer than a year, it's really going to leave my mom financially compromised. So the whole point of today is to talk about, how do we make sure that that doesn't happen? Are there ways that we can make sure to protect my mom? Or if you're a single individual, the ways that you can protect it for the next generation. So knowing what we know as to what's available and what can be protected, let's go forward and talk about ways that we can handle that. So Medicaid is a way that helps pay for care that you're not privately paying. So Medicaid will cover nursing home care and will cover the aging waiver program. So the aging waiver program is a program that would allow you to stay in your home but receive someone's coming into your home and providing that care. And we've seen that they can provide up to 24 hours worth of care, although in a lot of situations, you're not getting a full 24 hours, but you are getting a substantial number of hours covered. So that's the aging waiver program. So please know that Medicaid doesn't just cover nursing home care. It can also allow you to stay in your home and you can receive care that way. What Medicaid does not cover is personal care, assisted living, or any other in-home care that's not the aging waiver program. So whenever we meet with someone, if they're at the point where husband or wife is looking at needing care, the question is always, what level of care are you at? So if you think of it, Pennsylvania typically defines skilled care as if you need assistance with 2 out of the 5 daily activities of living. And the daily activities of living are things like grooming, bathing, making food, toileting, your ability to kind of be mobile in your area where you live. So those are all the daily activities of living. So if you get a physician to determine that you need assistance with 2 out of those 5, then you qualify for skilled level care, which is the level of care that Medicaid covers. Okay, so let's talk about the 5-year look back period. And if you think about today's presentation, we're kind of starting at the base. We're talking about what is Medicaid, what does it cover? Then we go on to talk about what's available, what can we exempt, what's not available to pay for care. And then we're going to start building on that and talking about ways that we can plan and protect assets. So the way that we shift to talking about protecting assets is we do have to talk about the 5-year look back period. So the 5-year look back period is saying that any time that you make a transfer of over $500 that's not considered some sort of consideration for payment or services, it's considered a gift. The default in Pennsylvania is that it's going to be considered a gift. So any amount over $500 is going to be subject to the 5-year look back period. That being said, if my dad needs long-term care, he can gift up to $500 a month. Now, that's not $500 per person he gives it to. That means my dad has $500 total that he can gift every month. As soon as it goes over that, then it is subject to the 5-year look back period. So we see this if children's names are added to the deed, if property is transferred, it's going to be over the $500 a month. And so it's going to trigger a look back period. So the important thing to know is that the maximum look back period in Pennsylvania is 5 years. I always get the question, is it 7? Right now it is 5 years. In Pennsylvania, they're always proposing to extend it to 7. When they extended it to 5, I think it was around 2005, it used to be 3 years, they extended it to 5 years. Anybody who had already started the look back period under 3 years, they did grandfather those individuals in so that they didn't have to start the look back period with the 5 years. If they'd already started it counting down, then you did get the 3 years. So we're assuming that if they would ever increase it from 5 to 7, anybody who's already started their look back period would be grandfathered in, but we'd have to see if the legislation would ever pass, what that would entail. So as of right now, it's 5 years. So that's the maximum look back period. But if you transfer assets, so I was meeting with some clients earlier in the week where they were talking about transferring $100,000. So the way that you figure out what your look back period, which is really just the period in which Medicaid won't cover the cost of your care, you would have to privately pay or find other insurance means to be able to pay for it, is for every $11,099 that you transfer is 1 month that Medicaid won't cover your care. The maximum number of months would be 5 years, okay? So if they transferred 100,000, we would take 100,000 and we divide it by $11,099, and that would give us a certain number of months, and that would mean that Medicaid wouldn't cover that person's care for those 3 months because they've made that transfer. So that individual would have to find a way to come up with that money for those 3 months. Once they make it through the 3 months, though, then Medicaid could begin covering their care. So that's where the 5-year look back period comes in. The maximum amount is the 5 years. And here at our office, our goal is if we can pre-plan, if we can have husband and wife or a single individual come in and say, we want to protect assets. If we can do it early enough and we can transfer those assets, then you could make it through the 5-year period. And then what would happen in my parents' case is my mom could keep her retirement, she would keep the house, and she'd be able to keep 130,000 plus anything that we were able to transfer that made it through the 5-year look back period. So that's why it's so crucial to do the planning before you're in the middle of a crisis. I know that we have some clients who have had to deal with either a parent or a spouse being admitted into a nursing home and they're kind of scrambling to qualify for Medicaid. And that's just because they're dealing with, can we make transfers? What's the look back period? But if you do it early enough, then you don't have to worry about that. And so what we're trying to do is educate people so that they know the earlier you do the planning, the more likely you are to make it through the 5-year look back period. Okay, so we're talking about transfers. We're kind of going up another level here, and we're talking about, well, how do we transfer assets and how should we approach those transfers? So, the most common misconception that people have when they come into the office is that they could just add their children's names to the asset in order to protect it against long term care costs. The short answer to that is yes, that may work in certain circumstances to have your child added to a deed or to transfer the assets to them. But it doesn't work in all situations, and there's a lot of risk when you do that. So the first thing to remember is that there are Pennsylvania inheritance tax implications to that. So if my parents, for example, added my name to something, let's say the house, the issue with that is if I would predecease my parents, then my parents are going to pay inheritance tax on their own house. So if they would add me, let's say they had mom, dad, and me, and I owned a third, or maybe I owned a half if they wanted to transfer half of it, and I passed away, my parents are going to pay 4.5% tax on one half of the value of their house just because my name was on the deed. So that's one thing I always like to caution people about. We never like to think that's a possibility, but we've seen it happen in just a few cases where the child has predeceased the parents. The second concern I always have is that if you completely transfer it, so you're not just adding your child's name to the deed, but you're actually completely transferring the property to them, I'm always concerned about mom and dad and whether or not the child will ever decide to kick them out of the house. Now, I haven't seen that happen, but it's always a concern because mom and dad no longer own the house. So, if they transferred it to me and I woke up one day and decided that I was not going to be a nice person anymore, I could ask them to leave the house because they no longer own it. So that's always a concern. The other issue is that the 5-year look back period still does apply. So when we're talking about transfers, you have to still do it in enough time to make it through the 5-year period. And a lot of people need to kind of refocus and think of it. You have to plan in enough time to make it through the 5-year period. And then the last reason that my parents might not want to add my name or transfer it to me is because of creditors. So when we think of creditors, we think of divorce. So if I would ever get divorced, I'm not married, but let's say I married somebody my parents didn't like and we ever got divorced, then their property, their house, their bank accounts, whatever I'm on with them is subject to that divorce. It's subject to any debt that I would have. So if I'm in a car accident and it's my fault, somebody's suing me, that property is subject to that debt. If I would ever get into a car accident and be disabled and I would need long-term care, then my parents' assets are available for my care. And then lastly, like we talked about, if I would pass away, my parents are going to pay inheritance tax on the asset that's in my name or that I'm jointly on. The other thing too is I did meet with somebody who they had transferred the property to the kids, had survived the 5 years, and they did it thinking that they wouldn't have to pay inheritance tax, that the kids wouldn't have to pay inheritance tax. But know in Pennsylvania that unless mom and dad are paying rent, so if they transfer the house to me and they're paying rent, then when they pass away, then the law says that yes, I don't have to pay inheritance tax on the house because I already owned it when mom and dad died. If, however, they still live there and they're not paying me rent as the owner, then technically it's still subject to Pennsylvania inheritance tax when mom and dad pass away. So there's all kinds of fun things that happen when you add a child to the title or when you transfer something to them. So although we always discuss this with our client, this is not the recommended way that I think we should use to protect assets. It is certainly a tool that we can use, but I always have to stress all the pros and the cons of doing it because there are so many. And most of the time, people opt not to do this because of all of the risks. So, what other ways can we go about planning? So, how do we protect those assets? So the first way is that you can talk to your financial advisor. There are a lot of great long-term care insurance products that are available, whether it be traditional long-term care insurance or it might be a life insurance with a long-term care rider. Any of those are options. So I always encourage clients to explore that option, to get quotes, see what it involves. Now, the major downside of using that, the investment products, as a way to pay for long term care is that unless you can get a locked in rate, a lot of times you see the premiums increase. Sometimes they can increase drastically from year to year. So we had a client who we saw a 17% increase from one year to the next in the premium for their long-term care insurance policy. So another way that we can protect is that we can work with a financial advisor and we can create irrevocable trusts that protect assets. And I always like to work with a financial advisor because we really consider them kind of the quarterback of the plan. We're just coming alongside offering some ways to help them protect assets. And I think that's important because it does allow the assets to stay invested as they are. So when we're talking about irrevocable trust, it doesn't require a cash in of those assets. They're still going to stay invested how you have them invested. It's just the title is going to be in a trust as opposed to in individual names. So I wanted to make sure to mention that. And then the rest of the presentation, I really want to go over in as much detail as possible how these trusts work, because although we've talked about it as a planning tool, we haven't really talked about the specifics. So I wanted to devote the next 29 minutes to talking about how these functionally work. So I'm going to use my family as an example because that's the easiest way to go about doing this. So I'm one of four girls. I have two older sisters and one younger sister. And so if I were going to talk to mom and dad about an asset protection plan, what I really want to discuss with them is the fact that this plan is designed to help clients protect the wealth and to keep it invested and to protect it against the creditors. It also is really important to know that this protects that spouse. So in our example of my mom and dad, my dad goes into the nursing home. We don't want my mom to be financially compromised because my dad is in a nursing home. Now, that does not mean we want to transfer all their assets into the trust. So we never recommend all assets being transferred to an irrevocable trust. Our goal is to set up these trusts and then to either choose certain assets to fund the trust or to pick a certain amount that we want to be protected for the spouse. So that way you're still going to have assets outside of the trust. You're still going to pay care to a certain extent, but it's just not all of your assets are going to be used to pay for care. This is about positioning a client in the best tax structure to minimize taxes as well. So being that I'm a little bit of a tax nerd, I always want to make sure that we are minimizing or not paying any additional tax as a result of using these trusts. So that's important to know. The other thing to know is that sometimes we have business owners who are concerned about protecting assets, and trusts are the only way to protect those business assets against long-term care costs, because even an LLC or a corporation or a partnership, those assets are still available for each partner's long-term care. So I wanted to make sure that we touched on that these trusts can be used for business interests as well. It also we can structure it in a way that it protects the future generation from divorce, death, disability. And that will be more apparent as I'm able to kind of show you what we do with the trust. And then lastly, our goal is to make sure that the clients aren't giving up the control. We still want them to be in control, still be able to make decisions. We don't want to transfer anything over to the kids at this point. All we want to do is really kind of put a fence or a protective barrier around those assets to protect against long-term care costs. So it's not about hiding the assets. It's really a plan that uses the existing laws. We're allowed to do this type of planning. So it uses the existing laws to create barriers that prevent creditors from being able to attach to personal assets. And that's really the benefit of using an asset protection plan. So I wanted to show a little picture. So every time that we meet with clients and they decide to do asset protection, we always do both a written plan, and the written plan is just using everyday terms and not the fancy legal terms that we actually have to put in the trust document itself. It's using everyday terms to kind of write out what we're recommending, what we're transferring into the trust. But then we also do a visual. I'm a visual person, and I know that a lot of people, it doesn't make sense unless they can kind of see what does it look like, how does it pay out. So what I thought would be helpful is for me to use the example of my family and put it into a visual. So this would be if, let's say, my mom and dad met with me and they wanted to create an asset protection plan. And in this case, we're going to talk about two types of trust. So we're going to talk about an income trust, and then we're going to talk about a regular protector trust. The reason that we use the word protector in the title is that's really letting us know, us here internally in the office, as well as the client know that the whole point of this trust is to protect it against creditors. The biggest creditor that we think of is a nursing home. So whenever you see the word protector in the title of the trust, that means that it's protected against long-term care costs as well as any other creditor that the client would have. The other thing to notice is you're going to see the word income only in the title. And we do that so that it alerts everybody here in our office, as well as the client, that husband and wife, the client, they're able to withdraw the income off the assets that are generated, any income generated off those assets owned in the trust, they're allowed to withdraw that. Okay, so that's important to know because you can make it an income trust or you can say, no, we don't want access to the income. So those are the two types of trust. The reasons that you want to have access to the income is maybe you still want to receive the interest and dividends yourself. Maybe you have an investment product or an investment account, I should say, and you want to transfer that into the trust. Let's just say it's $200,000. So you want to put that into the trust to start the 5-year look-back period, but you still want to be able to receive the interest and dividends that $200,000 creates every year. And so in that case, we would create an income trust where you, the client, can withdraw the income without needing any additional assistance from anybody else. So the way the trust is set up is that, for those of you who aren't familiar, a trust always has a trustee and a beneficiary. And then you have the person who creates the trust, who we call the grantor. Those are the three main positions of the trust. We have the trustee, that's the person who manages it. The beneficiary is the person who can receive distributions from the trust. And then we have the grantor, that's the person who created it. So in the example of my parents, mom and dad would be the grantors. They're setting up the trust, they're transferring whatever assets into the trust that they want. They would be the grantor. When we're talking about protecting assets against long-term care costs, the important thing to know is my parents can still be the trustee. So they can still manage, make investment decisions, still have all the control over the asset because they're still the trustee, okay? But what we do is normally the trustee has investment decisions as well as distribution abilities. That's normally what the trustee does in Pennsylvania. But what we do is we bifurcate those roles. So we say mom and dad can invest it and make all day-to-day decisions about those assets. But if they actually wanted to pull the assets out of the trust, they would not be able to do that because we're taking the power of distribution and we're going to give it to the position that we call the trust protector. Title kind of says what they're supposed to do. They're supposed to protect the assets owned in the trust protector. So in this case, let's say my parents decided that they were going to list all four of us, my two older sisters, myself, and my younger sister as the trust protectors. So the only power we had in this trust is to the extent my parents needed us to make a distribution out of the trust, at their direction, we can do that. Now, no, in this current picture, my parents can reach into the trust and pull out the interest and dividends because it's an income-only trust. So the only time they would need my sister and I is if they wanted to withdraw like a lump sum of the principal invested. So if they transfer $200,000 into the trust, they could pull off the interest and dividends every year without anybody else. They could just do that. It can be deposited in their bank account. But if they wanted to withdraw $20,000, maybe my dad wanted to buy a new vehicle, so he could ask my sisters and I to reach in and pull out that $20,000. That's what our job would be, and our only job is to reach in and pull out assets for whoever is the grantor. So that's how these trusts work. Because my sister and I are the ones who can reach in and pull out the assets, and my parents can't, that's what protects the assets against their long-term care costs. It also protects my parents' assets against my sisters and I's creditors because we don't own it. We only have distribution powers. My parents still own it, so it's not subject to our creditors. So it's protected against our creditors, divorce, car accidents, anything like that. And it's also protected against my parents' creditors because they don't have the power to reach into the trust and pull out that trust principal. So that's where we get the protection in Pennsylvania, is because we've taken the role of trustee and we've said, okay, clients, mom and dad, you can have all the power that the trustee normally has, but you just can't reach in and pull assets out that we're going to give to your children. You still own it. You can still buy, sell, make all the decisions that you want, but they're the ones who pull the assets out at your direction. Now, here's the interesting thing. If, let's say, my parents came to my sisters and I and asked us to make a distribution, and we told them no, this trust allows my parents to fire them. They could fire myself, they could fire any one of my sisters, and they could appoint someone else as long as it's not them. So we had a situation once where it wasn't that the child was doing something bad, it's just that they lived out on the West Coast. And so parents wanted to take 20,000 out of the trust. So we actually just used the one child who was here locally. So know that this type of trust still allows you to fire anybody who's not doing what you ask them to do. So this trust, this picture here depicts a trust where the clients, in this case, my mom and dad, could take the interest and dividends off the trust assets without any involvement. And then this trust also says that upon the second spouse's death, it would pay outright to my sisters and I. So it's almost like it has a will embedded in it, okay? So any asset transferred to this trust, the good news is it's protected against my parents' creditors, it's protected against my sisters and I's creditors. It's also, in this case, it's not considered making my sisters and I liable for my parents' long-term care because it's still owned by my parents. So if they don't make it through the 5-year look-back period, we can reach in and pull out those assets to pay for their care, or we can completely terminate the trust if we need to. So that's why I like this, because it doesn't make the children financially responsible for mom and dad's care like they would be if they were added as a joint owner or if it was completely transferred to them. Because it's still considered my parents' asset, we wouldn't have to worry about my parents going into a nursing home and my sisters and I being financially obligated to use our own personal funds. So that's the other important thing. There's also, if something would happen to, for example, myself, it's not going to trigger any inheritance tax because, again, my parents still own these assets. So it's almost like a container. Or the way I like to think of it is, if you think of a trust as like a closet, which in some of our previous examples or our previous seminars, we've talked about this. If a trust is like a closet and my parents build it however they want, and they put whatever assets they want into that closet, and then they shut the door and lock it, they can make decisions about if they want to replace things that are held in the closet as long as the value stays the same. But if they actually want to open the door, they could only open the door with someone who has a key. So let's say they need it open. I'm the person who has the key. I can unlock it and pull the assets out for them. So that's really, when you're thinking of a nice metaphor of how a trust works, it works well to think of it as a closet where somebody else has the key that unlocks it for you. So just let's advance, because I wanted to then talk about what would we put in this trust. So on the right side of the picture, you're going to see that the grantor can still buy and sell. So if you would put, for example, real estate into this property, my parents would still be the ones who decide whether to buy and sell. Because if you think of the closet analogy, the value stays the same. They're just selling the property out and getting cash into the trust. So they wouldn't need my sisters and I involvement in that. They can also make investment decisions. If they sell the property and they want to take the sale proceeds and invest it, they are the trustees. They have the ability to do that. So they can make all investment decisions. They're going to receive all the statements still. They can also hire and fire that trust protector. So again, if I say no, I'm not going to agree to make a distribution, my parents can fire me and appoint one of my other sisters to open that closet door and pull the assets out for them. The other thing my parents can do is they can add or remove beneficiaries. So for example, if they wake up one morning and decide they don't like me, they can remove me as a beneficiary. So even though it's an irrevocable trust, you're not giving up power and control like you would be if you completely transferred it or added that person's name to it. The other important thing to know is although probate in Pennsylvania doesn't cost a lot and isn't overly burdensome in Pennsylvania, the benefit of these trusts is it does avoid probate. So anything that's owned in this trust when you die, it's not subject to the probate process, which is great because that also means that attorney's fees are capped as well. So that means that the attorney can only charge 1%, or they would have to charge hourly for the time and work they spent on the file. They're not going to be able to charge like 4 or 5%, depending on what the value of your estate is, which they can do if it goes through probate. So that's the other important thing to know about these type of trusts. When you look on the left-hand side of the picture, you're going to see things that we might want to transfer in. So one thing that makes a lot of sense is rental property. And that's because you might, if you have a rental property worth 200,000, you might want to protect that 200,000, but you still might want to get the rental income off of that property. So that would allow you to still get the rental income while protecting that rental property from long-term care costs. The other thing too is you can put a business interest in here, because if you transfer an LLC interest, you can still take the income that you want off, but the actual value of the business is protected. You can put investment accounts in here that you want to receive interest and dividends off of. And you can also designate this trust as the beneficiary for retirement accounts. So we're going to talk about retirement in some later slides, but one thing to know about this is that if you are married and you've named your spouse, so let's take my parents. My dad has a retirement. If he goes into a nursing home, that is subject to his long-term care costs. That retirement can be used to pay for his care. My mom's retirement cannot be used to pay for my dad's care. But if my mom predeceases my dad, so my mom passes away, my dad's in a nursing home, it would be helpful if my mom's retirement paid into a trust, because then it doesn't make my dad ineligible for any benefits he'd be receiving in the nursing home. So although we don't transfer retirement into the trust because it would trigger all the deferred taxation that you've had all at once, we do have people either draw it down slowly and move it into the trust, or we have people designate this trust as the beneficiary, because although it's available for their own care, it's not for their spouse, but as soon as you die, it is then available to the spouse if the spouse is the primary beneficiary. So if we name the trust, then it wouldn't go to pay all to the nursing home. Now, let's say in this example that my mom passes away, my dad's not in a nursing home. In that case, remember, my dad is the trustee of this trust. So if he's not in a nursing home, he can disclaim, which means he can say, as the trustee, I don't want it to pay to the trust. I want it to pay to the contingent beneficiary that's listed on the retirement account. So that way, if my dad's not in a nursing home, he can disclaim as the trustee, and if we name my dad as the contingent beneficiary, my dad can still receive those retirement benefits. So this allows us to do planning, not knowing what order someone's going to pass away or knowing if somebody's going to need long-term care. So it gives us the flexibility when someone passes away to do planning after the fact. You can't do it the other way though. You can't name the spouse as the primary and then the trust as the contingent, because if the spouse is the primary beneficiary and they're in a nursing home, that retirement does go to pay for their nursing home care. But you can name trust first, then spouse. And if the surviving spouse isn't in a nursing home, they just disclaim and it would pay to them outright. The other thing I want to note before we move on is that the income is available, because in this case, my parents want the interest and dividends or the rental money from the rental property, because they have the ability to receive it and pull it out without someone else helping them. That income is available to pay for their long-term care costs, but the principal amount is not. So in our example of the property or the investment account worth 200,000, the 200,000 is protected. But if it generates $2,000 worth of interest or dividends or rental income, that rental income is still available to pay for my parents' long-term care, because they have the ability to withdraw it without additional signatures. Okay, so know if you're going to have income that you want to pay out, that's perfectly fine. We can set up the trust like that, but just know that the income is then going to be available for your long-term care. Okay, so this is the other way you can do the trust. So you're going to see in the title that it doesn't have the word income only in. So what that means is that the assets are transferred to the trust and the income is not coming out to my parents. That means anytime they want to receive any funds out of this trust, it would require my sister and I just to sign off on that. Now, again, if we don't agree to it, my parents can fire any one of us, and it can be the remaining sisters who would sign off on it. So you can always hire and fire that trust protector. But again, what this does is it protects the income and the principal. So again, because mom and dad don't have access to withdraw the interest and dividends, even the interest and dividends are going to be protected. And the look back period starts when you transfer assets into the trust. So if you've transferred assets in and you've made it through the 5-year period, then both the asset you transfer plus the income is going to be fully protected against long-term care costs. So what two things do we most often fund this trust with? Life insurance. The reason is if you have a life insurance policy and it has a cash value that exceeds $1,500, $1,500, that cash value would be available for your long-term care costs. So what we do is if we have a client who has a life insurance policy with cash value, we just transfer the policy into the trust so that that is protected against long-term care costs. The other thing we put in here is real estate that's not considered rental or your primary residence. The reason why we do that is because even as the trustee, mom and dad still have the ability to sell the primary residence or anything in this trust, but then that means both the income and the principal are protected. And most of the time, the primary residence isn't going to be sold until both mom and dad pass away. And so, again, if mom and dad have the right to sell it, the sale proceeds are just held in trust or stay in that closet and you just invest them. And so it makes it a nice way to have some assets that are fully protected, income and principal. And sometimes people will also use an income trust. They'll use two trusts. They'll fund certain assets in the income trust and certain assets in this protector trust. It all depends on what you want to protect and whether or not you want access to the income. The other question I get asked is sometimes we'll recommend multiple trusts. That might depend on whether or not you want income or not. It also might depend on how much we're trying to protect and what your look back period is. Because sometimes we have clients who want to transfer more assets, they want to be more aggressive in their funding. But if they would need care within 3 years, it allows us to undo one of the trusts and pay through the remaining 2 years of the look back period so that we can protect the other trust. So that's why we sometimes may use other trusts. We may use multiple trusts. Okay, let's go ahead and proceed, Jeff. All right, so this picture is showing the things that we can do for the next generation. So know that this trust during mom and dad's life protects against long-term care. They don't have access in this trust to the income. So 100% principal and income are all protected against long-term care costs. And then what the trust can say is upon the second spouse's death, rather than it pay outright to my sisters and I, it could pay in trust to us. The benefit of that would be that if one of us would ever get divorced, if one of us would ever be in a car accident, if one of us would ever need long-term care and it's in trust for us, is protected against that creditor. And we don't have to go through the 5-year look back period because we never owned it as an individual. Because it started off being owned in trust, then it's protected against creditors. Now, the only exception to that is these type of trusts aren't going to be protected in the case where child support, where you have to pay that. And that's because that's not in Pennsylvania. That's not something that we can use a trust to protect against that obligation. But other creditors we can protect against. So if mom and dad want to set up a trust, and we see this a lot with real estate, because maybe mom and dad say, well, I want this real estate to go equally, but if one of them wants to sell it, they first have to offer it to the other three. So we may have it go in trust because if it goes outright, once we all receive our 1/4 shares, we can do whatever we want. We could, force the sale of the other three. So by putting it in trust, it also allows mom and dad to create some restrictions where, if I want to sell my 1/4, I have to offer it to my other three sisters. They could even put what they want the sale price to be or the formula to calculate what the sale price is. So I would say for those clients who come in and do asset protection with our office using these trusts, I would say about 80% of them do have it stay in trust or, divide, and each child has a separate trust share. I would say 80 to 85% of clients do that just because it's so nice to not have to start a look back period again if your children ever want to do planning. So here in this case, I could be my own trustee, I'm my own beneficiary, I can make distributions out of the trust. And because I never owned it as an individual, I still get some creditor protection because of that. So it does create a nice way for it to continue to go through the families. And so we like this option. And you could do this for an income trust as well as just a regular protector trust. Okay, the next couple of minutes, we went in detail about the trust. I wanted to talk about other planning opportunities for Medicaid. So, and this was really important. I had a client whose father wasn't very old, I would say, mid 60s, and he needed long-term care. And father had two sons. One son had special needs, and he was an adult, and he had had special needs all of his life. He was getting SSDI off of dad's benefits. And so, what we were able to do in that case is we were able to set up a supplemental needs trust for the son with special needs and transfer the assets into that trust. So, we set the trust up on Tuesday, we transferred everything on Wednesday into the trust. And when you have an individual, a child with special needs, there's no look back period. So in this case, dad, it was something that happened very tragically, very quickly. We needed dad to be able to qualify for Medicaid benefits very quickly. And the reason why is because son that's disabled was only in his early 30s. He's only in his early 30s. So he will have years to live. And so the thought was, let's try to protect as much as we can, knowing that son's going to have years to live. And so we set up the trust, we transferred all the assets into that trust, and dad immediately qualified for Medicaid benefits. There was no look back period for that. So I wanted to make sure to mention that is that if we deal with a client who has a child with special needs and we have an award letter from the Social Security Administration saying they've either qualified for SSI or SSDI, we can set up a trust and transfer in, and the client, mom or dad, would immediately qualify for Medicaid benefits. So I wanted to make sure to bring that up. And again, there's a lot of misconception about that because in the case that I'm talking about, this individual, it was the son, other son, he had consulted other attorneys, and the other attorney said, you're going to lose everything to the nursing home. And that's not true. You can protect those assets. So I think it's important to get information out there so people know that, the law has provided protection for those individuals. The other individuals that Pennsylvania law protects are caregivers. So if we have a child, we see this often with a child who's caregiving for their spouse. Couple of things I wanted to mention. So the first is that if that individual is living with parents, so we had a situation like that where son had been living there for probably 8 years providing care. In Pennsylvania, they will allow the transfer to that child who resided with mom and dad, and there's no look back period, as long as that child was living there and providing care for 3 years prior to someone needing a nursing home. And again, the policy reason for doing that is the thought is that that individual living there allowed that mom, dad, parents to stay at home and not go into a nursing home. So Pennsylvania allows that policy of transferring it to a caregiving child as long as they've lived there for 2 years. The other thing I wanted to mention with caregivers is if you have a child who's providing care. We had a situation where a daughter actually quit her full-time job to provide care for her parents. And if that's happening and mom and dad want to give that daughter or that child money, compensation for providing that care, in Pennsylvania, the default is that that's a gift, which would be subject to the 5-year look back period unless you have a caregiving agreement in place. And if you have a caregiver agreement in place, then mom and dad can use their funds to pay that child, and it's not considered a gift. And that's really important because we wouldn't want it to be considered a gift for Medicaid purposes, as well as we wouldn't want it to be considered a gift for the child, because again, then they would be financially responsible for mom and dad's care. So it's really important to know that if you're going to be a caregiver, you have a child who's going to be providing care, you want to have that caregiving agreement in place. Okay, a couple of other things to know is that if we're in a crisis situation where somebody's actively in a facility getting care and we need to get them to qualify for Medicaid, there's some medical expenses, there are attorney's fees, you can buy a new vehicle, and you can set up an irrevocable burial CD by going to like a local institution or financial institution and setting aside money. In Franklin County, you're allowed to set aside 19,000, 19,500. Not that you need to put that much in, but that's the maximum amount that you can. And again, none of these things will make it so Medicaid won't cover it, meaning there's no look back period. You're allowed to pay those expenses to bring your assets down so that you qualify for Medicaid. Okay, retirement planning, we talked about this. We want to make sure that the designations are updated. So the way we do that is that we tier our beneficiaries. We have the trust as the primary, then the spouse, and then the children. So that gives us some planning options during life and when people pass away. Our next topic is on veterans benefits, November 11th, which I do think might be Veterans Day, or it's around Veterans Day. So we're going to do something on veterans benefits. You can register by emailing Amy at our office at her email address, or you can call us. We're also going to be sending you a survey. We always welcome any feedback you have about what you liked, what you didn't like, and what future topics you might be interested in. That being said, I want to thank everybody for being on this lunchtime call. What I'm going to do is I am going to stop recording and I'd be happy to take questions. But thank you all so much. I'm Samantha at the law offices of Samantha Wolf.